Okay, good afternoon to everyone who came in person and via Zoom. Thanks for coming. We've got some, as you know, you're here for presentations today by the students of the Entrepreneurship and Business Law Practicum at the College of Law. So we'll be hearing 5 presentations today, one on limited liability companies and the law associated with them, then one on nonprofits, then one on agency law, which are things like responsibility superior, servants versus independent contractors versus employees, that kind of thing. One on premises liability insurance, and then one on trademarks. And the one on trademarks, that'll be the last one, and that'll be done by online on Zoom. So I guess, well, you don't have to go anywhere for any of them, but they're just so you know what's coming. So I think with that, thank you for coming. We've got a good about 15 people joining us, plus the class of students. So I will turn it over to Nick McDaniel to talk about LLCs.
Hi, I'm Nick, and I'll be presenting on limited liability as an entity. We're going to go over the creation of the LLC, IRS's treatment of the LLC, management of the LLC, the different types of LLCs, and then some.
The woman. Last year we just.
It was the first
now, and we'll go over the need for the LLC, and the need arose from the desire to more easily separate classes of ownership. With corporate shares, they could be designated as separate share classes with different rights associated with those shares. But with the LLC, you can just say this entity or this individual gets the surface rights, this person gets the rights to live on the land, this person gets membership rights, voting rights, and kind of a long form way of classifying it that's more conducive to just a general understanding and interpretation. There was a desire to afford companies limited liability that couldn't be achieved through the partnership structure. Partnerships can have limited partners that have limited liability, but the general partners generally don't get that same shield. And so there was a desire to beef up the liability shield, but which could be done through a corporation, but corporations lead to double taxation, with the corporation being taxed and then the shareholders being taxed via distributions of corporate profits. And that can lead to, that pretty much always leads to inefficient tax burden. It's pretty much always more efficient to just be taxed once at the individual rate versus the corporate rate and the distribution rate. So the Wyoming legislature created the first limited liability company through passing state legislation. All LLCs are creations of the state. Wyoming was the first state to authorize it. This created easily identifiable ownership interests, fewer corporate formalities. Corporations have annual meeting requirements, annual meetings, structuring requirements with boards, and LLCs just kind of do away with all of that. You can kind of get the best of both worlds with the partnership and the corporation. And that's kind of the theme of the LLC that we'll see. Again, it created protection greater than, at a greater level than partnerships were able to. Corporations do have more easily transferable interests. They're much easier to trade on secondary markets, and this is favorable for when you go public, and buyouts, they tend to prefer them for that being one of the reasons why. It's the LLC via the operating agreement can really specify it being structured however the members want to structure it. So it provides a lot of flexibility and it's just user friendly. That was the whole idea behind it. So members can have like interest in the profits, but not in the operations of the LLC, vice versa, or only in certain. You could have a family LLC where the a trust gets the business like a structure, but the children get rents. It's pretty easy to do it that way. So we're going to cover the IRS treatment of the LLC because this, the IRS treatment of the LLC is really instrumental in the growth of the LLC because corporations and people respond to tax treatment of the IRS. So when Wyoming first created the LLC, the IRS had to figure out how to deal with it and decide whether it was going to be taxed as a partnership or a corporation because there's no section on federal taxes for LLC. And they needed 2 years to figure it out. It's a big deal where this comes in because partnerships are taxes pass through entities and the LLC members get taxed, but you avoid the corporate double taxation. So this was going to be a key decision. The IRS initially decided to tax all limited liability entities as corporations. So this would include trusts, and it brought some concern on the part of trust owners and trustees. And so there was some lobbying and some movement. And in 1988, the IRS determined that LLCs could be taxed as traditional partnerships, which is really great news, while they can still maintain the limited liability protection and get partnership tax treatment. The determination would be based upon multiple factors, and it wasn't always entirely clear which way the IRS would go on your specific LLC. And that's not the best thing when you want best thing for a company, because companies desire certainty, especially in regards to taxes. It's a big deal. So in 1996, made effective for 1997, the IRS implemented check the box regulations. Checking the box means on your tax form, you can literally check the box and be taxed as in a corporation, and providing clarity to the LLC owners on how their entity will be taxed by the IRS. Here you can see that's really where they started to take off, where the state started adopting LLC laws in the 1990s. It's kind of small, but here on the left side, you can see corporations in blue, pass-through entities, which is largely LLCs contributing to that in red. And then it continues on. The numbers are kind of hard to find, but limited liability corporations and partnerships are just continuing to grow a little bit. It's hard data on that's kind of hard to find. It was through various but they're really taking off. We may see that change a little bit with the new tax acts, with corporations getting lower taxes, but LLCs have proven to be beneficial to the business community. Now we're going to go over management of the LLC, and this is going to be determined by the operating agreement. LLCs can be member managed and manager managed. Member managed LLCs have operations run by the owners of the company. Every member can act as an owner, and these are generally your single member LLCs, closely held LLCs, and smaller LLCs where everyone's involved, all the owners. There's and they're useful for just you're directly involved. There's no management layer that you'd see like in a corporation, similar to a partnership or sole proprietorship. Now with manager managed LLCs, this is where they can become useful when you start to grow your LLC, where you're looking for rapid growth and you want the founder to be freed up to go get funds or look at expanding the LLC, or it's already a large LLC and it's just too much for the original founders to do everything associated with it. And they want to create a form where managers manage the day-to-day tasks and the owners manage the big decisions. And this is all determined in the operating agreement and is subject to change. And I like to say the manager can also just be a separate LLC and can have, it's really up to the owners of the LLC to decide how they want to do this. Now we'll go over the LLC types. There are close LLCs, decentralized autonomous organization, DAO LLCs, L3C LLCs, low profit limited liability companies, and series LLCs. The close LLC is very similar to the original LLC that the Wyoming legislature created in 1977. It was officially created as a subcategory of the LLC on the Secretary of State's page in 2000. And it creates greater restrictions on membership rights and transfers, dissolutions. It can be valuable when you want to limit the ability of the LLC to be take on any type of form, because the LLC naturally can shift to the desires of the owners. But close LLCs are useful when families want to limit the ability of the LLC to shift and form and function. It's useful for estate planning purposes and family businesses. The Decentralized Autonomous Organization, DAO LLC, is the newest form of LLC, and it's only available as an entity choice in Wyoming. DAOs are organizations, decentralized autonomous organizations that exist online that can be operated through a programmed algorithm via smart contracts or via human interaction, or a combination of the two, which is probably the most common. And it's just a way to kind of create the LLC online, the partnership online, where operations and structuring are readily apparent and subject to change remotely without having to meet in person to change the operating agreement. You just vote on things, everyone gets to vote. Voting structure is subject to the smart contract, similar to the traditional LLC's operating agreement. And it just kind of was the next step of the LLC in the digital age. But there's some limitations. There's the risk of not having limited liability protection with a traditional DAO. So the DAO LLC in Wyoming should give more limited liability protection to members and operators and owners of the DAOs. And it also allows the DAOs to get an EIN like a normal traditional LLC, which allows the LLC to get a bank account, hire employees, and give out forms, W-2s, 1099s. It allows the DAO as a structure to operate in the real world. Like if a DAO wanted to make a building or something, they'd have to hire people even online, if a DAO wanted to hire people. There's still a lot of uncertainty, but Wyoming's just kind of experimenting like they did back in 1977, but here in 2021 is when they started. And they're meeting to update it every year, listening to the industry and listening to the state on what they can do to make them better. It also gives real legal recourse to these online entities that can use Wyoming's court system and chancery court if the need arises. The L3C LLC is a low-profit limited liability company. It's for for-profit companies that have a social mission as their primary goal. The primary goal of the L3C is not to raise as much money as possible, but it could be a social mission like greenhouses or donating food to people, or really any social mission. And it can't be political though. And it's able to accept money from foundations while qualifying those donations as charitable purpose contributions. They're called program-related investments. And one company was looking to raise 20 million. Online information said they raised like 2.1 million. They're based out of Jackson, Wyoming. There's 8 states now and thousands of these L3Cs. So it's another option available. Series LLCs became effective July of 2018 here in Wyoming, joining other states that already had implemented Series LLC legislation. Series LLCs can be thought of as holding companies with subsidiaries. Really their creation for the benefit of companies and the individuals that own those companies, because every company that gets registered has $100 online. It's $102 and $50 annual reporting filing fee. There's series LLCs now that have hundreds, saving tens of thousands of dollars a year. And so it's great to just bring those entities here to Wyoming, just showing them that Wyoming's always innovating with the LLCs. It allows the parent LLC to divide itself into many different LLCs, with each series having its own business purpose, assets, bank account, and limited liability if done properly. But as a warning, failure to create separate EINs, bank accounts, operating agreements creates the risk of losing separate limited liability protections. Decisional law is unclear currently, and there are dangers associated without properly separating the limited liabilities, as you would a separate LLC. We're going to look at if the LLC is right for your business. We'll go over the benefits of the LLC, the limitations, and Wyoming specific LLC benefits. The benefits of the LLC are number one, limited liability protection for the business owners, which is a really big thing when you don't want to lose your house over having a coffee stand. And it allows for pass-through taxation. So you get the benefit of the corporation with the liability protection, the benefit of the partnership with pass-through taxation, and you get freedom to contract via the operating agreement, setting up however the owners wish, however the members wish. There's no annual shareholders meetings, and the reporting requirements are much easier than a corporation. And you can also have anonymity. You don't have to reveal ownership interests in the LLC publicly, and you can people can own properties with LLCs, and just create a barrier between the public and your assets. which a lot of people appreciate. And that's why a lot of people go to states with strong anonymity protection, such as Wyoming. Well, the limitations are, if you're looking to really grow a company and get bought out, investors tend to prefer the corporation structure just for a few reasons. Mostly is taxation can get complicated a little bit, and the free flow of shares with the corporation is just more conducive to corporate buyouts. Wyoming's specific LLC benefits are the Chancery Court, which is new. It's going. It allows for much more judicial expediency in determining cases, and it can create certainty in the judicial system via case law, similar to what Delaware has established in the corporate context. Wyoming has no personal income tax, no corporate tax if your LLC decides to be taxed that way, and it doesn't look to be changing anytime soon. There's strong anonymity protections and low state filing fees, only $50 a year. And with the Series LLC, that can really add up in corporate savings. And also, it's just a strong business friendly state. The legislature is receptive to industry wishes on developing the L3C, the Series LLC, the Dow LLC, and many more things. So I'll open up to any questions you may have.
You folks online are most welcome to ask questions as well.
All right.
All right. Starting with our next presenter, we'll ask them to plug their laptops in and actually share their screens. I think that'll take care of the dismal brightness that we've got on the projector behind the speaker.
All right, my name is Karen Speckner, and today I'm going to talk to you about nonprofit formation, as well as the 501c3 tax exemption. So the first question you could ask is whether a nonprofit corporation is right for your organization. And so here are some of the things to consider. First, you serve a specific population through goods and services. So you have a do-good mission for people you want to help. Next, you have long-term goals for the organization. So let's say you're a small group of friends who want to raise money to buy park benches, to update park benches in the park. And it's like a $2,000 project. You want, say, 2 fundraisers and it could be done. You probably don't need a nonprofit organization or a nonprofit corporation in that case, because it's a short-term goal. All right, next, you don't intend to personally profit from the organization, hence the name nonprofit. You also want some protection from personal liability, and this is similar to what Nick had been talking about previously in the LLC presentation. An example I like to give groups, let's say that you have a big picnic in the park that you want to present your big idea of helping others. You organize this picnic and people come. Your potato salad goes bad. And you have 100 people with food poisoning and medical bills and want to know who's responsible for it. So without this type of corporation, this formal corporation, the people there could be individually liable. So that's one thing to consider in these matters. And last, you want to build trust with the community. By being an organized nonprofit corporation, you establish trust with the people you want to help, as well as the people who are going to donate to you. So we're going to break this down. This is according to the Wyoming Nonprofit Corporations Act. A nonprofit corporation is an entity formed for religious, public benefit, or mutual benefit. When you see these bold terms, we're going to get into the details of those later. It's not intended for profit. Nonprofit corporations can apply for federal tax exempt status through the IRS 501c3 tax code. And nonprofits operate with the board of directors and may or may not have members or classes of members. Bylaws are used to govern the affairs of the nonprofit corporation. So next we'll go into those key terms, the legalese of this definition. So first you have 3 different types of nonprofit. Religious benefit is about what you would expect for churches and religious-based groups. Public benefit is what most nonprofits tend to be. It's a charitable group. Examples would be like Big Brothers Big Sisters or local food pantries. You are serving people through like charity, you're supporting arts, you're supporting education, those kind of groups. Mutual benefit is about what it sounds as well. Organizations that are formed to provide services to a limited number of members, but the members themselves are the ones who benefit from it. So think homeowners association, professional associations. Often it's funded by dues through the members themselves. And because of this, there's some trickiness with the 501c3 as far as its own members are benefiting from the nonprofit. So we'll discuss that a little bit. The first thing you want to do is have your articles of incorporation. And articles of incorporation are a set of formal documents filed with the governmental body to legally document the creation of your corporation. All of this is available, or the application is available on the Secretary of State website. There is a filing fee of $50, and the information you include is the name, your statement saying what kind of nonprofit you plan to be, contact information like the address, the name of the incorporators, whether or not the corporation will have members, distribution of assets on dissolution, and information about your registered agents. And again, we're going to get further in the weeds and dissect that a little bit more. And if you want to be a 501c3 nonprofit, there's certain language that can be included in these articles of incorporation. So definitions, what does it mean to have members in your organization? So a member means any person or persons who on more than one occasion, pursuant to provision of the corporation's articles or bylaws, have the right to vote for the election of a director or directors. So the big difference between an organization, a nonprofit with members and no members is voting control. Do you want your members to be able to help choose your directors and participate in big decision making? Or do you want the board of directors to be in charge of that on their own? So that's the difference between a member and a non-member. Dissolution is a fancy word of saying the process of ending the corporation, and assets must be dedicated for another exempt purpose. So let's say you're a food pantry that is dissolving. The funds that you have, the assets you have, you can decide to go to, say, another food pantry. That exempt purpose continues even after you have ended your own nonprofit. And here's some of that fancy language I was talking about that the IRS recommends. I don't know if you, I won't read it out loud, but it does sound very, very legalese. But it's it fits the requirements that the IRS wants for your nonprofit or a 501c3 purpose. Next, we have your registered agent. And the registered agent is somebody over the age of 18. They have a physical address in Wyoming and an email address. And they're in charge of keeping the contact information up to date for key individuals in the corporation. Two main purposes of having a registered agent. That's the person who will receive the annual report notices from the Secretary of State so that you know when it's time to file again. And it's also somebody who receives any legal documents if the organization is ever sued. So that's the purpose of your registered agent. After the articles of incorporation, you have your bylaws. The important term here is that it's an internal document that provides the rules of the corporation and the framework for its operation. So while the articles of incorporation are filed on the Secretary of State's website, your bylaws are not. That's something that's used within your own organization, saying how you want everything run. So it may include your purpose statement. So who are we? What do we do? Membership requirements and powers, director requirements and powers, roles of officers. So all of this is kind of saying what everybody's role will be, how your meetings are going to be run, your quorum format, when you're going to have annual meetings, all of that stuff is information that you put into your bylaws. Also tells you, like I said, with roles of officers, what's your president in charge of, your treasurer, your secretary, how long do you want a director to serve? That's all information that goes into your bylaws for your nonprofit. So let's say you have your articles filed with the Secretary of State, you have your bylaws in place. Now it's time to have your first organizational meeting. And that's you as the incorporator or incorporators, if there's more than one of you. And it's just to memorialize in writing what you as a group are deciding to do from day one. So in these minutes, you often confirm your articles of incorporation location. You can elect your directors and officers and approve your bylaws. And some of the optional stuff you can include are like permissions to give to certain individuals to perform tasks such as applying for the EIN, opening a bank account, applying for that tax exemption. And one that some may forget is the reimbursement for filing fees, especially if you're just starting your nonprofit and you don't have any money in the bank. There will be an individual who's putting forth that money for those fees. And you can write into these minutes that there is money in the bank, they can be reimbursed for that. So now we'll move into the 501c3. So why do it? The biggest benefit is the tax exemption. It also brings some public credibility, like we talked about in that first slide. It shows you as being professional and organized. Often you have greater eligibility for grant funding. A lot of grants require you to be a 501c3 before they donate. And the biggest thing for a 501c3 is that your donors also receive a tax deduction. And here's an example of what, I don't know if any of you have donated to a 501c3 organization before, but often you'll get these type of receipts that shares, you know, the EIN, when there is a donation. And the big thing is this final sentence, no goods or services were provided in exchange for this contribution. The magic number for a receipt is $250, though it's never bad practice to give a receipt anytime you receive donation. And I won't go into this link today, but here is the website for that specific language I was talking about for the Articles of Incorporation, saying that you are a public benefit organization, have your dissolution language. So the IRS, there's no need to recreate the wheel here. They give you the language you can include. So as far as the process goes, you have your articles of incorporation filed, got your bylaws, you've taken care of that first meeting. Next, you can file for an EIN number through the IRS. Once you have that, you can apply for that 501c3 exemption. And you have your choice. between Form 1023 or 1023 EZ. And it depends on how much money you think your nonprofit corporation is going to make. If it's under $50,000, you can do the EZ form. If it's over, they prefer the long form. As far as receiving notice, whether it's accepted or not, the EZ form's much quicker. It could be, say, two to 4 weeks. Long form can take 3 to 6 months. During COVID, it took up to 9 months. So sometimes takes a little while for this to come through. Another thing to note is the fee. There is a $600 fee for the long form and a $275 fee for the EZ form. So it's not a small fee going into it, and all of it must be completed online through pay.gov. I believe that's a carryover from COVID. Here's your requirements for being a 501c3. You must be organized exclusively for exempt purposes. You must not be organized for the benefit of private interests. So you can't say that we're organized for educational purposes and then use that money to pay off your student loans. That's not a nonprofit. You can't benefit privately from this corporation. Not to be confused with, especially for larger nonprofits, you can have employees, but you're also still subject to payroll taxes and all that stuff. Last, political and legislative activities are restricted. You can't support one candidate as an organization. You can participate in some bipartisan activities or encourage people to get out and vote. You can hold debates as long as everybody's invited to come. It's more about remaining unbiased. So here's a part I think a lot of people forget or can get them potentially in trouble. Even though you've done all this initial work, there is some upkeep that you have to do to remain in good standing as a nonprofit corporation, especially as a 501c3. So annually, you will file a report with the Secretary of State online, and there's a $25 filing fee for that. It's pretty basic contact information that you're sharing. Same with the big thing they want to know is that there is no compensation paid. There's a box there that you check. Next, you have through the IRS then a 990, a 990 EZ, or a 990N. And those are all dependent on amount of money you make in the year. The 990N is the one used for the $50,000 and less. And some information that they will ask is your corporation contact info, revenue and expenses, program services, activities that you performed. And as you can imagine, the 990N doesn't require as much information as, say, a 990 will. But this is also something that's filed annually. And finally, the thing to remember is that your articles and bylaws, consider them to be living documents. Nothing is set in stone. So say you decided initially you were a member organization, 10 years later, you realize it's just the board that's showing up to the meetings. Or your bylaws say we meet the 1st of June every year, and you haven't done that for the past 3 years. You meet in December. There's nothing set in stone. There are ways to amend your bylaws and your articles to fit your corporation as it changes and moves. So here are some good resources to use. The Wyoming Secretary of State website, the IRS has a lot of different available resources as well. And something important to say here, while these forms can be completed by anyone, consulting with a lawyer and or an accountant can help you meet the specific needs of your nonprofit. So never be afraid to ask for help. Are there any questions?
Hello, this is Devin with the Wyoming Small Business Development Center Network. And I have a question for entities applying for nonprofit status with the 1023 EZ. If in the future they receive more than $50,000 in donations or revenues, are there any additional forms that they'll need to file?
So I believe. That's okay. So this is something that I am learning as I go as well, as both a law student and a member of nonprofit organizations. I believe the 1023 EZ, depending on the amount of money you make, I think it's based on a three-year average, and it's okay if there's a year or two that you're outside of that number. And if that's the case, or if you find yourself consistently making over $50,000, I don't think it's a problem to move up to that 1023 long form. It's okay to shift between the two, as far as I know.
You just have to refile.
Yeah.
If you're consistently above, you just have to file the long. So basically as an amendment.
So yeah, it's okay if you change your mind down the road.
Thank you.
Right. Hello, everyone. My name is David Henrich, and I will be talking about agency law. So today I'll be covering what are employees or agents, what are independent contractors, and the legal idea of respondeat superior, or in a more general sense, how the actions of one affect another. So before we begin, just real quickly, I just want to go over what the difference between the agents and employees are. So an employee is almost always considered an agent. So think about a Walmart cashier. If they are an employee of Walmart, they're also an agent of Walmart. But an agent does not always have to be an employee. There are other forms of agents that exist besides employees. But for today's purpose, I will be using agent and employee pretty interchangeably. So what is an agent or an agency relationship? An agency relationship is created by a fiduciary relationship where one person, the principal or the owner or the employer, manifests assent to another, the agent, that the agent shall act on the principal's behalf, subject to the principal's control, and the agent manifests assent or consents so to act. So in other words, your owner or your employer asks someone to do something for them, they're going to act on their behalf, the employer is going to tell them what to do, how to do it, and the agent or the employee agrees to do that. So what is an independent contractor? An independent contractor exercises independent employment, contracts to do a piece of work according to its own methods without being subject to the control of the employer, except the result of the work. So in this sense, the employer gets to pick what needs to be done and gives them kind of an end goal or a project to be done. But the independent contractor gets to pick how they do it, somewhat when they do it, and kind of how they're going to reach that result for that final goal. So some factors to consider when telling them apart. This is not an exhaustive list by any means. There's a lot of things that different courts will consider all over the US. But some of the main ones that Wyoming itself considers is control, right to terminate, type of compensation, furnishing of equipment, and then contractual language has an asterisk by it. It's always important when you're doing employment contracts, whether with an independent contractor or an agent, that you're saying what they are. And you're calling them either by an agent or an independent contractor by what you want them to be. But agency law is a type of law where actions speak a lot louder than words. So the asterisk is there because regardless of what you call someone, whether it's an agent or an independent contractor, the way they act is a lot more important. It tells a lot more than what you call them. So control. What looks more like an agent? Control over the day-to-day operations. So whether you're an employer or an owner, you are controlling how these employees are doing what they're doing for these agents. So back to our cashier at Walmart example. The owner there or the manager is going to tell them how to do their job. They're going to give them instructions, training. They're going to tell them when they're going to come to work, when they're going to leave, what register to be on, etc. And they're going to look like an owner or an employer of this person. Or as an independent contractor, think of an electrician as a subcontractor. Where if you're building a house and you hire someone to wire your house, you're going to tell them you want your house wired, but you're not going to sit there and tell them how to do it. You're not going going to tell them where they need to do it. You might tell them, I need my house done here and here. That's why you have a little control over the process, a little control over the methods. So you get to pick maybe the wire that's used. But you don't get to sit there and micromanage and tell them how to do everything, or they wouldn't be an independent contractor. Right to terminate. Wyoming is an at-will employment state. So when you have an agent or employee, you can terminate this relationship at will with a few exceptions that I won't get into. And what looks more like an independent contractor, the question that needs to be asked, if I terminate this relationship, could there be a contractual breach? So think back to the electrician. If he's halfway done with my house and I tell him to leave and I don't pay him anything, there might be a claim there for damages for me not paying him for the work that he's done. Type of compensation. What looks more like an agent is an hourly wage or a salary. You're continuously paying someone to do a job for you, whether it be hourly or salary, and as they work, you continue to pay them. Whereas an independent contractor, it's most likely going to be something more along the lines of a lump sum, or pay upon completion, pay half in advance, half upon completion. It's just going to be you're paying for a project to be completed. You're not paying them as they work through it. Furnishing of equipment. What looks more like an agent is you're providing the tools, you're providing the employees that they work with, and sometimes transportation is provided. So in our case of our Walmart cashier, transportation is not always going to be provided, but they're providing you with the actual cash register to do your job. They're providing you with a name tag, a vest, and they're providing you with all the other employees you work with. So you look a lot more like an agent. What looks like an independent contractor, back to our electrician, they're most of the time going to bring their own tools. They're going to bring their own team of people to work on it. They're going to bring their own transportation to and from the work site. So that's going to look a lot more like an independent contractor. So between these two, employee agent, independent contractor, it's clear differences. Your cashier is all the way on your left side there, one of those triangles. Your electrician is all the way on the right side. Everything's sprinkled in between, where some of those factors might weigh a little bit more in the other direction, but it's still a clear line, right? Well, actually, this line looks a lot more like this. And so you still have your cashier, you still have your electrician that are safely on either side. But when you get a little bit more where these factors are weighing differently, different jurisdictions, different courts, and different people will see them differently. So while the facts might be extremely similar, in one state, they might be an independent contractor, in another, they might be an agent. So where you want to be is as far on either end of the spectrum as you can possibly be. Stay away from that middle line. Make it extremely clear in everything that you do, whether it's control, furnishing equipment, contractual language even, get as far on those sides as you can to make it very clear to you and to the person you're hiring, to every other third party, whether they're an agent or they're an independent contractor. So why does this matter? As long as the work gets done, what does it matter what you call the person that's doing it? Well, liability. So before I jump into liability, I've been using a lot of words and I haven't really described them very well. So principal, agent, and third party. When we're talking about liability, there's an obvious relationship between the principal and the agent. The principal hires the agent. The agent does work for the principal. And then there's an obvious relationship between the agent and the third party. If tort happens or negligence or contract, an agent is going to be working with that third party. And if a harm happens, the question that we are asking, or we're trying to find out, is whether this third party has a relationship with the principal and whether they could potentially seek damages with the principal. So we'll start with contractual liability. Principal is subject to liability if the contracts are made by the agent and the agent is acting within their authority as the agent. So the presence of authority here is what creates the liability. So what is authority? There's 4 types today that I'm going to cover. These include actual express authority, actual implied authority, apparent authority, and inherent authority. So actual express authority. Most of the time, this is extremely clear. There's not a lot of doubt in this one. You either gave permission as the principal or you didn't. So David, you have the authority to hire an assistant. If I, as the agent, went out and hired an assistant and something happened with the contract, the principal gave me this express authority to hire the agent, so there could be liability for the principal. Actual implied authority. So the agent is told to do something. To complete the task, the agent does some things that are not explicitly allowed, and the authority includes what is necessary to complete the task. So David, go pick up the supplies. I go to, say, a lumber yard or an office supply store, and I go pick up the supplies that I was told to go grab. Upon getting there, I'm asked to sign for things and I have to talk to someone to get the supplies. I was never given permission by my principal to sign anything or talk to anyone. That's the implied authority that they gave me, was to act and to sign for those supplies, to talk to someone with those supplies. So that's the implied authority that was given to me. So apparent authority. Principal never gave actual authority, regardless of it was implied or expressed. There was never any authority given. But the agent sets themselves out to have that authority. And the third party reasonably believes that the agent has the authority and relied on it. So think of a manager hiring or not having the authority to hire anyone, but conducting interviews regardless and hiring someone. So regardless of whether the principal gave that permission, and even if they never did, the manager sets himself out to have that authority to go hire people. They conducted interviews and they hired someone. The principal in this case could be contractually liable to honor that employment contract. And I have ordinary course of business down there. This is something to keep in mind. The ordinary course of business is things such as, in my example, the manager being able to hire someone. Is this a field of work the managers are typically allowed to hire people? That would be in the ordinary course of business. And so agents acting within the ordinary course of business it's a little bit more to the third party to believe that they have that authority to do so. And then inherent authority. I'm going to quickly go over this one because this one is pretty mushy. And most of the time, if someone is looking to get liability through or to a principal, they're going to go with one of the other three forms. So ordinary course of business, again, does the third party believe, and is it reasonable that the third party believes that this person has the authority to do this? Is this typical of what someone in that position would be doing? Disclosed and undisclosed. I just want to touch on this real quick. Inherent authority, you can, whether the principal is disclosed or not, there can be liability. So if the agent is acting as if no one else, he doesn't answer to anyone, there's no one else above him, he still is doing these things, whether he discloses that there's a principal or not, the principal could still be liable. This is rare, but just be aware that it exists and that you should know how to kind of combat this. So now, respondeat superior. We are going now to a little bit more tort liability with negligence. So in Wyoming, this is defined as an employer will be held liable for the negligence of an employee who is acting within the scope of employment. So the employer or the principal will be held liable for the negligence of their employee or their agent, either one, as long as they are acting within their scope of employment. So what does that mean? Scope of employment is defined also in Wyoming as conduct of an employee is within the scope of employment only if it is of the kind he is employed to perform, it occurs substantially within the authorized time and space limits, and it is actuated, at least in part, by a purpose to serve the necessary. And so earlier we discussed when deciding whether someone was an agent or an independent contractor, we went through factors. These are things that the courts weigh or a third party's weigh, deciding what someone is. This is an elements test. And so there's three elements here. You can tell that by the and at the end there. So everything in this paragraph needs to be true to find that they are within the scope of their employment. So to break this down, conduct of an employee is within the scope of employment only if it is of the kind he's employed to perform. So, employed to perform. This is where employment contracts come in really handy. So be extremely specific when you're hiring someone, an agent, who is going to act on your behalf of what they are allowed to do and what they are not allowed to do. This goes back to contractual liability as well, giving authority. If you're explicit in what they are allowed to do and what they are not allowed to do, you could avoid, or they could be acting outside of the scope of employment. They are acting outside of what you give permission to do. And I say ordinary course of business again, because if you don't want an agent to do something, but you don't think of it, you don't give express permission, you don't think they're going to do it, but it's within the ordinary course of business and they do it, that could still be acting within the scope of their employment. So be extremely explicit of what is allowed and what is not allowed. So the second element there is it occurs substantially within the authorized time and space limits. When analyzing this, there's two questions that need to be asked. When did this occur and where did this occur? Was this within normal business hours while doing a task for the principal at the location that work is being done, like an office? Or was this 200 miles away on a Saturday afternoon, completely outside of their work obligations? So these are the questions that need to be asked in whether this is in their time and space limits as an employee or an agent. The third is actuated, at least in part, by purpose to serve the master. And as a purpose to serve the master, was it furthering the objective of the principal, or these actions undertaken to benefit the principal? And so the example I used a little bit ago with whether it's a Saturday afternoon 200 miles away, well, that doesn't really matter if they are 200 miles away on a Saturday afternoon meeting a client for you as an agent. And so this is acting within their scope of employment because they're serving a purpose for their principal. Then just as a comparison, independent contractor liability defined in Wyoming is an employer of an independent contractor is not liable for physical harm to another caused by an act or omission of the contractor or servants. This is pretty similar for contractual liability as well. So independent contractor, most of the time not liable, besides some extra circumstances where an agent will cause liability for the principal. So just to review real quick, know what an employee is or an agent, know what an independent contractor is, and make it extremely clear when you're hiring someone what they are, whether they're an employee or an independent contractor. And the reason for this is you need to know what your liability is before you even get started hiring someone. Know what you want and know what your liability could be. And if you have specific questions about your business, seek an attorney who practices agency law. There is a lot of exceptions in everything I've talked about today, and there is a lot of small details that really matter. So find someone that specializes in this and they'll be able to answer your questions. Questions? My email is up there if anyone has any.
Here's one, does a business attorney know?
Say, I would say yes. It's business attorney is a very broad category of an attorney, but I would say agency law is underneath the business umbrella.
All right, good afternoon. My name is Joe Speckner, and today I'd like to talk a little bit about premises liability insurance and the harm that can make you need that. So the thing that I'd like to talk about is what is covered, what isn't covered, who does premises liability insurance protect, how do you know who is responsible, and then the business considerations, how much coverage does your business need, and then I have a few slides at the end dedicated to just some general considerations to help make a better informed decision when you're contemplating buying this kind of product for your business. So to start with, you need to know, what does this kind of insurance product cover? And the first and more obvious is bodily injury. If someone is hurt on your property and you are found liable, this type of insurance might cover those medical expenses. Next, maybe less obvious, but just as important, are defense costs and settlements. If you're sued and the insurance company has a right and a duty to defend the suit, and will often cover the cost of settlement. So here, if somebody's injured on your premises and you are sued, whether those charges look frivolous or not, or have merit, the insurance policy is going to pay for the cost of the representation to fight that claim. And then lastly, third-party property damage. Some policies cover this where there might be damage to a third party's property while it's on your premises. The quintessential example is if your shopping cart from your business rolls across the parking lot and smashes into somebody else's car. Some policies cover this, some don't. It's always important to read and understand what your coverage is. Next, as important as it is to understand what is covered, it's also important to know what isn't covered by premises liability insurance. If one of your employees gets hurt, for instance, say you have somebody up on a ladder and they fall off and get hurt, That probably wouldn't fall under this type of insurance claim. That would be more of a workers' compensation claim. If your property, your building, equipment, inventory is damaged, this probably wouldn't cover that either. That would be more of a commercial property insurance type product for those types of damages. And then also, if one of your customers gets hurt in the course of your business from, say, professional error, more than likely you would have like a malpractice insurance type policy to cover those kind of damages. And then I guess it should be noted also that anytime we're talking about insurance products, if you willfully or wantonly hurt somebody on your property, man traps would not be covered under premise liability insurance. Now, it's important to know who does premise liability coverage protect. You may have heard all sorts of different quotes from people over the years about dividing people in this world into haves and have-nots and whatnot. But really, the only three categories you need to know are invitee, licensee, and trespasser. Well, what are these people? Well, an invitee is a person who is specifically invited on your property. This would be your customers. It is your responsibility to exercise reasonable care for the safety of these people. What does that mean? You're expected to regularly inspect your premises for dangerous conditions and correct them, or at least warn these people. Next are the licensees. This might be somebody you didn't expressly invite to your property, but is still a person who has permission to be there. This would be like delivery people, utility workers, postal workers, even salespeople that would be associated with something to do with your business that you might expect, although you didn't specifically invite them. The law says that you generally aren't expected to keep your premises free of obviously dangerous conditions for these people, but you are expected to keep your premises free of concealed dangerous conditions and must correct or at least warn these licensees of their existence. But as always, best practice, you should always make reasonable efforts to keep a safe business premises. It's just good business practice. The last category of people that you need to be concerned with on your place are trespassers. You may have heard a story that's been around, I think, forever about the burglar that broke into somebody's house, tripped over a stool, broke their leg, sued the landowner for damages and won some giant personal injury. Well, that's a myth. Trespassers is a person who does not have permission to be on your premise, and in general, you are not liable for injuries to trespassers. And that's a point that isn't always well understood and can come as a good point of relief for business owners or even property owners in general that don't always know that. It should be noted, though, there is in Wyoming, there is one notable exception. It's called the attractive nuisance for minors doctrine. And what it is a special carve out for people in their tender years who may or may not be able to be held to the same standards as everybody else. The perfect example is if you had an old fallen down treehouse on your property, and it looks like to the neighbor kid walking by that he just can't help himself. He just needs to climb that thing. And there's about four things to consider as to whether it falls into the attractive nuisance exception or not. One is whether or not you should know that a child would want to climb up into that nuisance. Number two, whether or not you know it's dangerous, if it's rotted, and you just know that anybody who walks up there is likely to come down before they intend to. And three, if the child is probably not going to be aware of that on approaching the attractive nuisance. And then the last thing to determine whether it's an attractive nuisance is kind of a balancing between how easy it is for you to protect the minors from the damage versus what the possible harm is. So sometimes that can be starkly different. Next thing a business owner should be aware of and should understand is who is responsible. Like, when is the business responsible? And what I mean by when, where is the key? Things to think about: is your business in a building with shared office space? Do you lease your space? If an accident occurs in a common area, depending on the terms of your lease, you could be responsible for that. If you lease an entire building, you may be responsible for injuries that occur in the building and in the parking lot. The best practice is to make sure that you read and understand your lease agreement. The lease agreement will often expressly spell out who is responsible for what and where. Once you understand where you're responsible concerning the area around your business, then the next thing you can do is go read your insurance policy and make sure that all the areas that you are responsible are covered by the policy. And then lastly here, some of this can be a little tricky. You should never be shy about reaching out to a lawyer to help you make sure that you've got your ducks in a row here. He can help you understand what you're responsible for, where, and then he can even provide you with other advice on how to structure your business, like Nick was saying earlier with LLCs or whatnot, to limit your liability to begin with. So I guess the $1 million question: how much coverage does a business need? You know, you can always start by talking to your insurance agent. But hey, remember that they work in sales. Anytime I think about this type of relationship with a salesperson selling me something, I always think of an interview I saw years ago with Warren Buffett, where he was asked how much stock he puts in the opinion of the investment bankers that handle all the mergers and acquisitions for his company. And he said, well, very little, if not none. He says that's about like asking your barber if you need a haircut. The answer is always yes. And so, not that the insurance agent doesn't have some value, but just always bear in mind that they're here to sell a product. So things that you should consider for yourself is, well, how risky is your business to begin with? As an example, a bar or those type of businesses are really risky for obvious reasons. And on the other side of the spectrum would be businesses that are more office oriented, where you may or may not even have in-person contact with customers and other people. Those type of businesses would be a lot less risky. Next thing to think about is, what is your asset worth? What is your business actually worth? If your business is just starting out and you don't have a ton of value in your new LLC or corporation, you may not need quite as much coverage. If you have a ton of value in there to where any one judgment on a large personal injury claim could get into a lot of money, 6-7 figures, you may want to buy more insurance. But something to keep in mind, this is not something that's one-to-one. It's more of an additive effect. If you buy a policy and the judgment against your company maxes out the policy limits of your insurance policy, you might be liable for any judgment over and above that. Another thing to think about is that when you're shopping around for this kind of coverage, as the coverage increases, as essentially the dollar amount increases, the incremental cost of that additional insurance tends to decrease, just owing to the idea that most personal injury claims are probably going to be at the lower end of the spectrum, and the larger and larger claims are probably going to be more infrequently happening. And then the last question that you have to answer is one only a business owner can answer for himself. And it's how much risk are you willing to have? Everybody has to make this decision for themselves, but you need to know the lay of the land in order to make an informed decision. Here I will go through a few tips to reduce these liability claims. Like I said before, you should always make reasonable efforts to maintain safe conditions for the people on your business property. Things that you should do: maintain your property by clearing debris after a storm, removing snow, making sure the parking lot and walkways are free of ice. Make sure your stairs are sturdy and have proper guardrails. Promptly clean up spills or accidents and place wet floor signs where appropriate. Routinely inspect for water leaks, plumbing issues, and the like. Make sure your floors are all free of debris, loose flooring, and other tripping hazards. And then something that might not always be readily apparent, but you need to make sure that your lighting is good and that walkways and parking lots are adequately lit in the dark. And in closing, I wanted to say, remember, gravity is not your friend. Slip and falls are the most common type of a premise liability claim. And anytime you have a question regarding anything in this area, I just encourage people to reach out to a lawyer. An hour of time from a lawyer might save you a world of cost later down the road. Would anybody have any questions?
Thank you very much.
Just go to the previous slide, Kira, real quick. Okay, so you're good. Go ahead and get it started.
Okay. So just in case you guys didn't hear, my name is Kira Lukens. I'm the student director for the business law practicum here for the College of Law. And today I am going over trademark and business logos, kind of from a 10,000-foot view. So the trademark is based off of the Lanham Act, which was enacted by Congress in 1946. Is there an issue, or are we doing good?
Go ahead, Kira, you're good.
Okay. So the Lanham Act comes out of the United States Code 1052, or Section 15, and it was enacted by Congress in 1946. And basically what it says is that trademark is any name, word, symbol, device, or any combination thereof. And this is not, the best way that I put it is it's not completely inclusive of everything. And I think it's actually a little more strict. And as we'll see more what can be trademarked. So the Lanham Act does lay out strict guidelines on what can and cannot be trademarked. And so we'll go over what can be first and then what cannot be. So for starters, wordmark and design is kind of what we think of when we think of trademarks in general. So obviously for Wyoming fans, the Steamboat, so Pistol Pete and Cowboy Joe together, as well as the wordmark for Barbie is trademarked. Coca-Cola is another common one that has trademarked that entire design and wordmark. Color is also trademarkable. This is an example of what came out of a Qualitex case. They were a laundry facility and Qualitex made these laundry steamer pads that were this green gold color, so that when laundry facilities saw these pads, they knew that it was coming from Qualitex. And then another company came in and made similar colored steaming pads, and Qualitex said, no, like, we have this color trademarked. The next thing that can be trademarked is a fanciful name. So a fanciful name is a name that was made up. So for example, here we have Kodak Photos. The nice thing about using a fanciful name, or one that you come up with on your own, is it does have a greater threshold and it has stronger protection around it, because the likelihood of somebody coming in and saying, oh, I'm going to do Kodak Pictures versus Kodak Photos is very slim that they'd be able to pass that, because Kodak isn't somebody's surname, or it's not describing a feature of the cameras in general. Short phrases are also under trademark. So the better ingredients, better pizza for Papa John's is on there. Other things that are commonly trademarked, sound. So the NBC chimes that you hear, those 3 chimes are trademarked. The smell of Play-Doh is also trademarked. And something that is a common question here is, well, if I make a marker that smells like Play-Doh, there's a chance that you'd be able to trademark that smell for a marker, but you would not be able to trademark your own putty type something, even if it's like a silly putty or something that's not necessarily a dough. That Play-Doh smell is specific to that type of putty. So now we're going to go into what cannot be trademarked. So what can't be trademarked is going to be under section 1052 of this Lanham Act. So 1052A says that anything immoral, deceptive, scandalous, falsely suggested of a connection with a person, institution's beliefs, or national symbols is not to be trademarked. So for example, if somebody came forward from one religious institution and said that this is going to be part of our institution, and kind of try to confuse the waters of that, essentially, that is likely not to be trademarked. There was also a question recently about Kanye West trademarking the White Lives Matter, and whether or not this would be considered scandalous matter or immoral. And what ended up happening was it was trademarked, but it was trademarked in order for other people to not use it, so it wouldn't be used in commerce. 1052B says that flags, coat of arms, other insignia of the US or any state or foreign nation cannot be trademarked. So state flags is a really great example of this. So for Wyoming and our southern friend Colorado, you would not be able to come forward and say, hey, I'm going to put a trademark on the state of Wyoming flag. What you may be able to get away with in Colorado, it's a little more common, is you'll see people using those C's incorporated in another design that they've created. And there's still always a question. And again, I say, like, talk to a patent and trademark attorney, because they're going to know these more nuances in this, but you have a greater chance of possibly getting something like that trademarked, but certainly not just the flag itself. So 1052C says that a name, a portrait, or a signature identifying a particular individual cannot be trademarked. And I think that this one's probably one of the harder ones to kind of understand, in that I could potentially write out my signature as part of a design for a business and potentially have it trademarked, but like, you can't take the John Hancock and say, I'm going to use this and trademark it, as well as the Queen of England. You wouldn't be able to take her face and say, I'm going to trademark the Queen of England's face and call it good. So 1052D, I think, kind of goes without saying, excuse me, that something previously registered with the USPTO, or USPTO is the United States Patent and Trademark Office, and that would not be allowed up for trademark. So for example, Coca-Cola, you can't go in and say, hey, I'm going to trademark this Coca-Cola sign. No. So this is also a great slide, I think, because Coca-Cola's word mark has been trademarked, as well as that red color for soda. So kind of like for soda cans. So kind of what we were talking about earlier with the colors. There's like Big O Tires has a very similar color to Coca-Cola, but I wouldn't be able to go in and design a soda can brand that color because it likely would cause too much confusion for the consumers. 1052E says that names merely describing the object or a good, primarily a surname, or explaining what the function of the object is cannot be trademarked. So a computer company cannot come in and call themselves computer company and hope that that's going to stick, just as an Apple company can't come in and name themselves Apple company. Now, a computer company, as it has come in and trademarked themselves as Apple computers, as this is something that's not describing the actual object itself. So here's just kind of a little bit of a separation. So when you're looking at different logos or different pictures, you often see a TM or an R with a circle. I certainly growing up before coming to school thought it was kind of one and the same, and they're not. So for a state, that would be the TM. If you want to file with a state, you can, but you are also welcome to use a TM on your logo without registering and without filing. It is always safer to register with the state. This is something that you can do through your state's Secretary of State website. But what this also does is if you don't meet the requirements for that federal registration, you can start with the state or start with this TM. And what it does is it starts to build that evidence that's required for that federal registration. The federal registration is one that's very strictly says that you have to have this federal registration in order to use the circle R. In order to receive federal registration, you must have an interstate commerce or intend to have interstate commerce within 3 to 4 years. And what interstate commerce is you're having some sort of sales across those state lines. So where do we start? And this is talking about federal registration. This is what I'm going to focus on here. So where do you start? You're always going to start at the United States Patent and Trademark Office. Again, I'm going to put in another plug that getting an attorney for this is going to help because there's a lot of little tiny details that are really easy to miss, and you want to make sure that you cover all your bases here. So you want to start by making a standard drawing of your trademark. Are you doing just a name? Are you doing a photo? Are you doing a picture or a drawing? There's sound and movements and smells as well. And I'll get to that in a second, but we're just going to go super basic here. So say you want to come in and you want to make a name here. They did Smokyville. It needs to be on a black uppercase text with a white background. And this is for just the name. And you're going to have a clear description of the mark. Now, lower than that, I know it's a little small and a little hard to see, but it says Friends of the Smokies Trails Forever. So you want to write out a clear description of that mark. So you're likely in that you're going to say 2 green trees, 1 smaller green tree, 1 larger green tree, blue mountains in the background, 1 dark blue, 1 light blue. Then you could say 2 dark silhouette figures, 1 larger, 1 young child, and then a brown trail kind of down the middle. Excuse me. And then you're going to have just a brief explanation of the black text that's there. And you want to take this and you want to put it on a white background. When you file with the USPTO, they are going to assign a design code. So you can see that kind of down at it says design search code with those codes. And that's going to be what your attorney is going to help you go through, but what also the USPTO is going to assign. And what that does is that helps with searching, because what you want to do after you make your mark, now that you have the description, you're going to go and you're going to run a search to make sure that the description that you have, the mark that you have, and the potential picture that you have is not already in commerce. So you're going to go to the USPTO's website, and it's called the Trademark Electronic Search System, or TESS. I've also seen it a couple times as TEAS. They don't use it interchangeably necessarily, but from what I'm understanding, it's the same thing. So there is a basic word mark search where you're just going to go in and type it in. The word and design mark search is what I'll go back here a second, is what you're going to use for these design codes. These designs, so O2, or the O2, O1, O2, the men depicted as shadows or silhouettes of men. That would be what you put in that design mark search when you're looking for a picture. Again, I cannot stress enough how important it is to find a trademark attorney for this, because those little nuances, those little numbers, knowing what to search for. They do have a design search code manual that can help, but just knowing specifically what you're looking for to make sure that you've covered all of your bases when you're searching for potential other marks is essential. So here's an example of what happens when you pull up a search that you made. So here, the Starbucks word mark that they use is Starbucks coffee. You have the goods and services that they're doing. You have that mark drawing code, and then you have the design search code. So if you put together a picture that has, say, 2 stars, a mermaid, and it's yellow, what you're going to do is you're going to look for stars, that those design codes that are saying stars, 2 stars, the mermaids, but what you're not going to find is the yellow, because Starbucks doesn't have the yellow, but it has the potential of pulling up those different marks so you can see how closely yours fits and if there's a potential for infringement there. As you can see too, and I'll kind of cover it later, you re-up your trademark every 10 years. And so it looks like Starbucks just redid theirs here in 2022. So then what you're going to do is you're going to classify your mark. So a class for your mark, the way that I kind of think about it is you want to think about all of the things that are going to be associated with your mark. So I'm kind of going with the Starbucks theme here as again. So Starbucks likely has the coffee. They potentially have the coffee mugs. They potentially have unroasted coffee beans, because this is just a specific coffee one, not specifically what's associated with them. You want to think of everything that's going to be involved with your mark, because what happens when you file that, that's locked in. And you can always take things away. So say like for your mark, you want to do coffee and you want to do tea, and you want to do mugs and you want to do clothing. You put all of that in there, but then you decide that you want to do just the coffee, tea, and the mugs, you can take the clothing out. What you can't do is if you do coffee, tea, and mugs, and you're saying, oh, I really want clothing to be associated with my mark as well, you can't go back and tack that on at the end. It has to be what you classified with when you filed. So it's kind of a rock and a hard place too, though, because the more classes that you add, the more expensive it is to file your mark. So here's what I was talking about a little bit ago about what is required to have a federal registration. So you must show either that you have a use in commerce, in interstate commerce, and you must provide that evidence. So this is what having that state registration is beneficial for. You can retrieve that state registration and show, hey, like I have this state registration. I've been using the trademark TM sign. That's a great place to start. There's obviously other evidence that you can do as well. The other thing is an intent to use, and you must show that you intend to use with good faith, intent to use within the next 3 to 4 years. This is a little bit harder, but it's certainly not impossible. So then the next thing that you're going to do is you're going to file. And this is all done electronically through the USPTO office. And this is just kind of, I know it's really small for the people in the classroom, and I apologize for that, but this is just an example of what different types of applications. And what you'll do when you get in there is you'll make an account and you'll put in what you're looking for. You'll put in what you need as far as an application, what type of mark you're trademarking, and then they'll go from there. As you can see in the bottom right, it says enter mark here. This is where you're going to place that dark or colored, either just the word or your design on the white background. This is if you need to do a translation of your mark. And then this is where you're going to put that strong description, go as descriptive as you can. You're going to put the colors of the mark in there. Check this box if you're not claiming color as a part of your mark. So For example, the Coca-Cola symbol, they likely did not check this box. They left it blank because they were trademarking that red color. Again, this is just different options of what this application but looks like, but also showing how intense it is. Like, it's a very intense application. So to finish up, I just want to talk about why do we not want to do copyright? One, trademark has overall more protection than copyright does. Copyright does have a time limit. So a copyright's time limit is if you put and you present a photo. So here the Underwood deviled ham, if they had come and had the little photo of the devil plus the ham, then the life of that copyright is the life of the person who created it plus 70 years. So this can change and you can get extensions as we've seen and heard in the news, but trademark's indefinite if it's still being used and it's not abandoned. You just have to renew it every 10 years. So the Underwood deviled ham is actually the oldest still in use trademark today. And the one below it is the Averill Chemical Paint Co. And that is the first trademark that was ever approved by the USPTO, but it is no longer in use. Thank you.
Okay, questions, anyone? All right, well, thanks everyone for coming. Thank you, Kira, for talk. I think what's going to happen next is I'm going to get these recordings to Jill Klein, or the one giant recording. And I think, is this right? You'll kind of try and chunk them up and put them somewhere for your
Yes,
folks?
yes.
Okay, great.
We'll probably put them on our website under our events.
Gotcha.
Okay.
Okay. Cool. All right, well, thanks everyone for coming.
Thank you.
Including those in person and on Zoom.
Thank you.